So thank you for coming out tonight. I know we have a bunch of people logged in online. So, certainly speak up if you got any questions. If there are questions online, you can feel free to submit them as well. Tonight, we're going to be talking about the value of mediation. And first, I'm just going to go over a couple of our presenters here. My name is Mike Macomber. I'm the CEO here at Tully Rinckey. I've got, I don't even know how many years of employment law. That's all I've been doing since I got out of law school. I like to focus on a lot of the federal claims. We also do a lot of work with the federal government. Most of my day-to-day involves running the firm at this point in time, but every now and again, I still dabble in the occasional labor case. Joining me as well is Alan Shoikhetbrod. Alan, you want to introduce yourself?
Sure. I'm the managing partner of our Latham office. I predominantly practice in labor and employment law, federal side, state side, public sector, private sector. So really all types of labor law violations, employment law violations. And
Perfect. Next, we got Glen Doherty as our resident employer-based attorney. Glen, you want to tell a little bit about yourself?
Right. I'm the opposite of Mike and Alan. One, they're better dressed and smarter, and they represent a lot of aggrieved employees and plaintiffs out there. I'm on the other side of the coin. I represent defendants and all that is labor and employment. And to that end, I've had cases with both of these gentlemen, and they do a super solid job, and that's why I'm here helping out today.
Thank you.
Thanks for letting me be here.
I hope we got this recorded today. I want to hear those comments back later. And last but not least, by all means, we got Judge McCarthy here as well. Judge, you want to tell us a little bit about yourself?
Sure. I'm Bill McCarthy. I've had about more than 30 years in state government service in various positions as a law clerk, working in the executive branch of state government and the judicial branch. And for the last about 7 years, I've been doing mediation and arbitration at ADR practice.
Nice. So point of tonight, we're going to go over from a high level, a little bit of discussion on the various employment laws that come into play. And then we're going to talk a little bit more about, as the title suggests, the value of mediation and hearing a little bit from different sides of things, hearing from a plaintiff's attorney, hearing from a defense attorney, and hearing from a mediator as to some of the different themes and topics that come up when evaluating employment claims. We do have an agenda. I'm going to do my darndest to stay on point, although I know that's probably not going to happen at all. But we're going to go through a lot of the various employment laws first, some recent Supreme Court decisions, some of the key elements that come up in employment claims, and then we're going to get into a little more of a roundtable discussion about some of the issues in mediation. A couple of the various laws that we're going to be going over. I'm going to have to remember to move this thing on behind me, so it'll be fun. There we go. Talk a little bit about the various federal laws that come into play in common employment claims. Title VII, the ADA, the ADEA, FMLA, FLSA, and USERRA. You can see we love our acronyms. We'll go into these in a little bit more detail here. But then we're going to also shift New York State. One of the things I love most about doing employment law in New York is there's never any end to the permutations that New York likes to throw at us, and it's an ever-evolving landscape. There are always differences in New York law that can sometimes be very advantageous to a plaintiff's attorney and probably give Glenn a little bit of a headache from time to time. And then also we're going to talk a little bit about the processes. Before you even get to mediation, how do you get to the table? Where do you file a complaint? What types of complaints can you file? What are the various agencies that will handle complaints and what that process looks like? So starting us off, we'll start at the top, probably the most cited of all. Talk a little bit about Title VII.
Yeah, so Title VII of the Civil Rights Act of 1964 codified 42 USC 2000E, I think is probably the most well-known civil rights statute dating back decades. But it does prohibit discrimination against employees on the basis of race, national origin, religion, sexual orientation, gender, and so forth. With respect to compensation terms, conditions, and privileges of employment. There is a requirement on the size of the employer, which is at least 15 or more employees for 20 weeks out of the year. And labor law organizations also fall under Title VII prohibitions, although there's no minimum size for employment agencies. There's a couple different claims that would fall under Title VII. There's disparate treatment, where someone is claiming that they've been intentionally discriminated against. There's also disparate impact, although not on the slide, but essentially saying that a group of individuals in a protected class are being discriminated against. Generally, under disparate treatment, you would look at it from the perspective of a motivating factor. There's two different burdens to establish a case of discrimination under Title VII. One would be direct evidence, literally someone having documentation showing discrimination would essentially fall under direct evidence. Most of the time, it's circumstantial. So if most of us know the McDonnell-Douglas burden shifting analysis, where you have to establish a prima facie case and it shifts back and forth between the employee and the employer. There are procedural requirements to assert Title VII claims. Although it does apply to public employers and private employers, there's still a process, an administrative process, which would be filing with the EEOC, the Equal Employment Opportunity Commission. Recovery is limited by statute under Title VII, but also under Section 1981A, which would be compensatory damages, which includes non-pecuniary and pecuniary, so out-of-pocket damages, back pay, front pay. We'll get into that in later slides, but also non-pecuniary, which could be pain and suffering. Back pay is limited for 2 years, and that 2 years is from when you assert your charge with the EEOC. There could be some injunctive or equitable relief, like enjoining the unlawful employment practice, and also affirmative action can be ordered in EEOC charges and in cases related to Title VII.
Before we go too far ahead, I think just a fun sidebar as we jump out here. I know a lot of legalese here. You as the plaintiff's attorney, we talk about the McDonnell-Douglas burden shift, right? You typically have to establish the prima facie case. And then from an employer standpoint, we're talking about the legitimate non-discriminatory reason for the action. Could you put us in some terms here as to what the prima facie case looks like? And Glenn, I'm coming your way next. What are some different types of non-discriminatory reasons that come up?
Sure. So I'll start on the prima facie case, since it's always the plaintiff's burden to establish discrimination. Everyone's in a protected class, right? Everyone would fall under Title VII protections. So one of the elements is, are you in a protected class? The second element is whether you suffered an adverse employment action. There is a Supreme Court decision that came out recently where basically anything is an adverse employment action at this point. But from there needs to be a causal link between the protected class and the adverse employment action. And sometimes that could get tricky. Sometimes you look at proximity. But generally speaking, establishing that first burden of a prima facie case is not that difficult. And then it goes to you as the employer.
Typically when I get my hands, on a defense situation, the first thing I look is I actually do try to chip away at your prima facie case, right? I mean, for example, sometimes I'll say there's no disability. You're not making another protected classification, or there is no connection or correlation. There's no adverse action, you're complaining about. I mean, it doesn't constitute an adverse action. Prima facie case, as I think Alan would agree, it's not a tough burden. But once you establish that, the burden then shifts to the employer, and typical for me is to articulate a legitimate non-discriminatory reason for why this person was demoted. And for example, I would say something along the lines of, this person, yes, was demoted. This person, I agree. I ignore it. I'll concede the prima facie case. This person was demoted because he makes the least amount of widgets of my 42 people, because he's come in late 60% of the time and no one else has. So I'll chip away at that. So my legitimate non-discriminatory reason is based on performance. It's as simple as that. Then the burden does what?
Then it comes back to me and my client to show that your reasons are pretext of discrimination.
That means just, bullshit. I mean, just so same page here. I mean, lying, I'm making it up. Well, which I used to do.
Most of the time it is.
Yeah.
We know.
Look, I mean, you called me out a few times.
But again, going back to the legitimate non-discriminatory reasons, I think, it's usually the case that the employer is going to have reasons. Whether or not it's legitimate, that's my burden to show that it's not. And so we get into pretext. And there's a lot of different ways. It really depends on the case, the type of case that it is. We stay with your example of someone being demoted. I'm looking at other comparators of individuals in protected categories outside my protected categories. looking to see if my client was treated differently compared to others dominantly. I'm also looking at employment policies, employer policies, handbooks to see if your client followed what it was supposed to follow. So really gets into a discovery issue at that point to really see, can I chip away at your argument? And assuming I establish that, then I think we defeat summary judgment and go to trial.
I agree. I mean, and that's why, I mean, in all seriousness, when an employer needs to articulate its non-legitimate reason, it is going to be fact-based. And if it's not true, it's going to be quickly called out as not true. Because if I start making claims of performance activity, lateness and all sorts of things or other sorts of discipline, you clarify our information, and I'm either going to quickly go forward and keep, raising my fist in the air, or I'm going to be ducked for cover, or give me something else. So,
Yeah.
It's a process. And you're right, discovery, is where my, non-legitimate discriminatory is going to live or die.
Right. And at that point, assuming we overcome those burdens, it becomes a credibility issue. So really for a trier of fact to determine who's telling the truth.
And we know it's always the employer telling you.
I was gonna say, and I know we like to pick on Glenn as the employer here, but having done a fair amount of that myself, there is also that potential in discovery that there's some bullshit excuses coming out of the employee as well. It may be that they don't technically have a disability. They don't actually meet the prima facie elements. And those are some of the pieces, as you point out, you kind of work away on, because sometimes the legitimate non-discriminatory reason's good, but they don't have the right documentation or they didn't do their due diligence. So now you're having to defend that.
Yeah, another problem, and not to go sideways, because really the real meat of today's seminar, I think, is the mediation.
Yeah.
You don't want to hear the three of us talk about crazy, horrible, boring law. It's really, the money show is McCarthy. That's just fun, right? But a lot of times when you get to discovery from the employer side, you better be careful, and when you're defending a case or you own a company, that your data is correct. I mean, it's really easy for a manager to say, this guy's a piece of crap. He comes in late, he leaves early, and he steals people's lunches. It's easy to say that, but if he's not doing it, I mean, again, Alan's going to come in and do some damage to discovery. So, before you start laying out your non-discriminatory reason, you better make sure that your managers, your HR team, put in that accurate, clean data.
Yep. No, I completely agree on that. Al, that's good.
I'm good. And I agree. I would jump all over that. I mean,
What, am I throwing you lob pitches?
No, I agree.
Is there a current case? Do you two need to go outside?
no, we resolve our case.
Good.
Resolve our stuff.
Good.
And we should.
Yeah.
And often we need someone like McCarthy, but sometimes we just want to do it ourselves.
Well, and I think understanding the various laws, I think a lot of the part, I poke fun at the state of New York, but there are a lot of areas and pitfalls that employers fall into because they don't know what the protections are, what comes into play, and especially smaller employers and things of that nature. The very large, Fortune 500 companies, they usually have robust departments that cover a lot of this. But there's a lot of pitfalls that can easily be stepped into. Alan, you want to... We'll get back to some of the material. You want to talk a little bit about my favorite term, reverse discrimination, which is a completely oxymoronic term, but whatever.
Yeah, I mean, to your point, discrimination is discrimination, and that's what the Supreme Court essentially held earlier this year. Ames v. Ohio Department of Youth Services. It's a pretty interesting case, and it was unanimous, actually, by the court. It essentially rejected kind of a split that was going on, and this came from the Sixth Circuit, where there was a heightened evidentiary standard on majority group plaintiffs that claimed that they were being discriminated against. In this case, it was a heterosexual woman who sued Ohio after she was denied a promotion, demoted, and previously the position was then filled by a homosexual individual. And she alleged it was discriminatory because she was heterosexual and female. And so the case went up to the Supreme Court. And really the argument was from the employer's perspective that there was a heightened standard, almost kind of had to establish there was like the company was doing this regularly towards heterosexual women. There's almost like a disparate impact sort of argument being made in a disparate treatment type of case. And the Supreme Court rejected it, basically saying that the plain language of the statute under Title VII protects any individual, and that applies regardless. And so the standards are the same. There is no reverse discrimination. It is simply discrimination.
And this does come up because we are seeing more and more claims of discrimination being filed. But I think the common terms of, wait a minute, it can't be because I'm either a male or because I'm white or because I'm in one of the, there's a term they use, but I think it's the more standardized, protected bases there that somehow doesn't, there's a different standard that should apply here. And it was actually a very well-written decision from the Supreme Court clarifying that discrimination is discrimination. It doesn't matter what protected class it's in, which really reaffirms what we've all been arguing for years here. Glenn, you want to cover a little bit about ADA?
Sure. I mean, ADA, just to let you know how old I was, I kid you not, when the ADA came into existence, I still had really dark hair. I had more hair. And I remember, being called in. I just came back to Albany, and I actually was on one of those Sunday morning talk shows that no one watches. And I was talking about the ADA, and I was offering up the opinion that, the ADA is going to be kind of a soft statute. It's not going to get a lot of action. It's, it's always going to be age and, Title VII and those kind of things. And, then of course about my 300th case, I needed to have to change my mind on that. Thank God that tape is hopefully destroyed by now, but I admit I did say that.
Proving yet again you were wrong.
Like 1992 it came into existence. That was a long time ago. But so look, when we hear about the ADA or the Americans with Disabilities Act, I mean, there's a lot of fancy kind of definitions and terms, but it's kind of simple. It says, it prohibits two things, or it addresses two things. It says, we're not going to discriminate against someone for having a disability. Simple, right? I mean, and discrimination means, treating them differently, denying a job, denying a promotion, termination, because of, again, a disability. That's direct discrimination. And I think employers, quite frankly, and maybe it's your, kind of your observation, Ellen, I think employers get that. I mean, they might not follow it all the time, but they get that. We can't discriminate against somebody that has a disability. I mean, that's right. It's just like discriminating against somebody on the basis of, sex or race or age. I mean, we get it. But what is often forgot in the kind of realm of the ADA is the statute also requires an employer to reasonably accommodate an employee with a disability. And so what does that mean? Look, you got to give the guy or gal a fighting chance. If there's little things you can do along the way to accommodate their situation, to let them successfully perform the essential functions of their job, right? I mean, a lot of times, these were easy in the beginning. In the beginning, it was, so all you need is 2 telephone books under your desk so you can get your wheelchair under it. Okay, that was a classically perfect, accommodation. Now, related to that, this kind of goes a little bit, off school or off of script here, is, look, when there's a reasonable accommodation, there is a requirement, okay, it's part of the statute. But when an employer has to engage in, it's called the interactive process, it has to, say, okay, so an employee comes in to an employer and says, and if the employee says, look, I've got a pre-planned doctor's appointment every Thursday. I've got a very, very serious illness playing off shit Thursday here. Oh my God, you're going to wreck up everything. Well, boss, all I'm asking is I'll come in 2 hours or, I mean, that's a discussion. It's the interactive process, and and it can end there, and it's a winner-winner. A lot of times employees ask for crazy things. Okay, I mean, I don't disagree, but some are crazy. Some are, I need a $16,000 golf cart to get me around the factory. Well, you can't walk. How are you going to operate my lathe machine or my roller? So you have that discussion, but the key for an employer in satisfying the reasonable accommodation obligation is just to sit down and look like, what do you need? The employer doesn't have to give you what you're asking for. The employer just needs to take this, engage in good faith, try to figure out if there's something that they can give that's not cost prohibitive, because we call that an undue burden, something that we can give that's going to allow you to perform the functions of your job. That's it. I mean, that's what the ADA does in its sense. It says no discrimination against disabilities. And when there is someone, who has a disability, granted, like to your point, I mean, look, if you're not disabled, then, stay out of this thing, right? But if you are, employers welcome you in, explore the process and decide and determine that, reasonable accommodations are okay. And the truth is, employers they don't mean to violate this. They just often do because what employers focus on is this. I didn't just, he came in a wheelchair. I was fine with that. Okay, that's great. But what you then didn't do is you didn't talk to him or her about, kind of workstation modifications, which are cheap, and now you're you're calling out a productivity failure when all you had to do was modify those, I think you and I've had some ADA cases over the years. The key is always the accommodation aspect. And that's the hot area. Is that kind of where you're seeing on the plaintiff side?
Yeah, on the accommodations, just because of the costs, just because, employers don't really want to modify the work environment too much. And it really comes down to the size of the employer too. And that goes to your point on undue burden. Smaller employers going to have a lot more difficulty than a larger employer. I do see a lot of pitfalls in the accommodation cases. The interactive process in itself is not a violation. Failure to engage in that is not a violation. What comes out of that may be the violation. And of course, under the ADA, it's a little different under state law. And we'll get into that a little later. But also what's interesting is the ADA doesn't just cover individuals with disabilities. It covers individuals that are perceived to have disabilities as well. And that gets into a little more fact specific because it comes down to whether or not you have medical impairments that substantially limit you, right? Or you're perceived to have those. So when you go back to what we were talking before about the prima facie, it's actually a lot more difficult to establish under an ADA plan, right? As to whether someone has a disability or perceived to have a disability as opposed to someone being protected under race or national origin. You get a little more fact specific there. But once you overcome that and you get into the essential functions, right? You need to be able to do the essential functions of your job with or without the accommodation. So if you can't even do your job, I don't need to accommodate you as a right. So, by the time you get to that point, there are problems already. And, it really depends on where you are in the case and how far along the issue has been going. But if it's something early, I think really it's just a sit down discussion, see if you can resolve it.
I agree. And thanks for the save on the kind of the perception. The ADA is one of the statutes that says, look, even if you aren't disabled, the fact that, we treated you differently because of our perception that you were disabled, certainly is going to make your prima facie case on that. And, along those lines, or also too, just in terms of the reasonableness is, look, I don't know, maybe 2 or 3 a week, I seem to get involved in kind of ADA accommodation cases or human rights accommodation cases, which we'll get to in a few minutes, is look, it's reasonable accommodation, just, so employers know it. And, often it's not a joke, but it's a reality that I have employees for my clients that seem to be asking for someone else to do their job and for them just to get paid. Well, I want that job too. And that's not a reasonable accommodation. Alan might argue it's a reasonable accommodation and, he might survive summary judgment, but it's not, right? But getting back to getting back to our prima facie case, when we have it, look, you got to make sure that, that employer is covered by the ADA because under, state and federal law, it's different in terms of the number of employees you have. Typically small employers aren't covered by the ADA. Yeah, that's great to say, and that's a big victory. But they are covered by the human rights law, which quite frankly, kind of gives back what the federal criteria took away. Right?
The human rights law makes the disability question almost non-existent.
Well, look,
which I love. I
don't know why you plaintiff lawyers ever even sue under federal law at this stage, and the state law is so pro. And then if we go down the river a little bit, you're in New York City. I don't know why anyone in New York City sues under state law, right?
I completely agree on that. You got to look at the boroughs.
Yeah.
And if you're in the city, you better file under the city. I think, one other thing on just the accommodation part, and I think where I see a lot of pitfalls is where employers play doctor. And that's a huge problem. You get in that interactive process. I have seen so many employers get into trouble because they look at an employee and they say, oh, you're a diabetic, I'm a diabetic. I know what you need. That's not the standard there. And they get into, as I said, playing doctor. They try and second guess what the individual's physician is saying. No, this is an effective accommodation. This is what they really need. Honestly, I think the first real employment case I had was a reasonable accommodation case. I had a client who just diabetic. His doctor said, listen, can we take him off the night shift? just needs to be on a day shift so they can sleep a normal schedule. There were openings, you name it. They fired my guy. Next thing we know, we filed an EEO complaint, and I got a call from, it wasn't you, but an employer real quick saying, whoops, we screwed this one up. What do you need? So I love the accommodation aspect because I think the medical aspect of it can be a lot of fun to dive into and figure out what is an effective accommodation. I don't hate the idea of the phone books under the desk, you know, and what does that cost you? They're giving them out.
They're burning them anyways, right? Yeah, no, I agree. And the other thing too is you talked about, you know, playing doctor. I haven't had so much of that. I've just had employers, and I really don't think employers need to triple the ADA or any comment or any kind of accommodation process through the human rights law. But they often ask for a little bit more initiative. You know, it is, you know, look, you know, when a guy or gal comes in, you know, they're opening their self to kind of tell you a little bit more about themselves and some problems they're having. And, you know, the jump right into, I want to see your meds and talk to your doctors. Sometimes it's a, you know, it's a bad trigger and then it involves people like you after.
It can get very triggering at that point in time, especially anyone with any kind of disability, because you're right, you're opening up very personal questions, which they've been dealing with their entire lives. And maybe.
And also, I mean, your medical condition, your medical records are protected under other laws, making it even more sensitive in other realms. So I'm curious, what you actually tell your clients to kind of limit from that happening in the future. Like, how do you deter it? Sure.
I say, go to your computer and I'm going to send you this 2-page cheat sheet of what you can and can't do in this situation. Because, you know, quite frankly, you know, employers get heads up. JoJo mentioned something to his or her manager. I got a problem. I got medical. You know, and when you say medical, probably disability, maybe not, maybe temporary, but you know, so we get heads up. You know, big employers are more kind of, you know, clued into this thing, and they react and say, okay, crap, this guy's coming in at 2 o'clock. What am I supposed to do? And I have a cheat sheet. Not that I'm trying to beat the employee. I want it done right. I really do. And you know, look, employers can say no when it's crazy accommodation. We just can now. You know, a good plaintiff's lawyer can come in and, you know, make my life miserable for a little bit, but we're allowed to say no, or we're allowed to say no. What, you know, I've got a different pull. Now look, I'm not a doctor, I'm not an occupational therapist, but I think this would work. I mean, tell you what, we'll put you have noise sensitivity. Okay, thanks for this medical. I'm going to put you in. You want to work from home. Okay. Well, you know, my business, quite frankly, I work so hard to get people to come back. I got to work hard to get people in, and it's good and social, and you know, we have Pizza Fridays. So I really don't want you working from home, even though you gave me this nice note from the doctor that said you should be working. I'll tell you what I'll do. This is a very quiet wing over here, and I'll tell you what, I'm gonna have it. You know, tell me you want to be alone. That's great. Tell me you want 1 or 2 employees. I'll work with you on that. And again, that's going to get me to the same place. Now, again, yeah, I think the employee does want to work from home, and I think doctors will say a lot of things that patients ask them to say. And I'm not saying they're lying. I'm just saying they're very much encouraged. But again, they're not agreeing to everything that, you know, has to be the case. And you know, if somebody says I want to work from home because I'm sensitive to noises and PTSD, it's like, well, you know, I have a very quiet environment over here that has no trackers, or I'll get you away from the kitchen or something. So those discussions happen.
What I really liked just that example you gave is it's a very good example of that interactive dialogue at that point in time, based on that employee, where I think a lot of employers, this is not a political comment, but the federal government just got in trouble this week. DHS or ICE or somebody said, everybody, there's no more work from home. And we don't care if you have a disability. And that lasted 24 hours before they rescinded that statement.
Those things.
Right now, I saw that one come out. I'm going, oh God, we're gonna have a lot of fun with that one.
The office and say, are you guys on this?
I'm just saying, who works for them? But that is a stark contrast from what Glenn just highlighted, which is that interactive discussion where, you know, somebody provides it, you say, hey, this is a solution, and maybe you get to there, maybe you don't. But those blanket policies get a lot more employers in trouble. A lot of great stuff on the ADA. Again, there's some more, details as to the specifics and definitions, but as we all say, we'll keep talking about this for till the cows come home.
Yeah, you know what? You're right. As I'm looking through your outline, because again, the real value is to get McCarthy talking and pick his brain, and so we can all get some free advice here.
We're gonna get to that.
We're going super boring.
We'll start boring and then we'll get to the fun stuff. Alan, you want to talk to us a little bit about Bostock and gender orientation?
Yeah, well, now, as we know, Title VII does protect against sexual orientation, discrimination, and gender identity, where it didn't before. That changed in 2020. The EEOC actually did recognize it, hoping for that, but the Supreme Court made it official. And New York State human rights laws we get to later had those protections in place for a while as well. So unfortunately, statutes tend to be a little behind, or in case law tends to be a little behind, but Bostock essentially codified that as a protection. Then we have the Pregnancy Discrimination Act and Pregnant Workers Fairness Act, also amended Title VII to make it illegal to discriminate against women because of pregnancy, childbirth, medical condition related to pregnancy or childbirth. New York State has expanded upon that as well. Then we have the Young case here as well, where someone may be temporarily disabled due to pregnancy and also covered under Title VII. So that has been expounded and expanded upon in the last several years, where New York State was always ahead. But for the law has finally caught up.
Can you tell us a little bit about at least what I think at least 3 out of the 4 of us are protected up here, maybe all 4 of us.
Yeah, at least on the federal law.
Thanks.
But,
Well, we all got it.
Yeah, we're all good on the state law.
but yeah, the Age Discrimination Employment Act protects individuals who are over the age of 40 from being discriminated against because of their age. Also has an employer requirement or employee requirement of 20 or more. Really does impact really anything having to do with terms and conditions of employment, but also with respect to pensions, mandatory retirement ages are prohibited in a lot of different sectors. But it is a different legal requirement. It is actually a higher evidentiary burden. It's a but-for causation. Which is basically the only reason is because of your age that we're taking this adverse action against you. And it's really hard to establish. But the ADA does not prohibit age discrimination where the employer can prove a bona fide occupational qualification. So for example, you see this a lot in law enforcement, where there are mandatory retirement ages, typically in the 50s, mid-50s. That is not illegal. And not a violation under the ADEA, for example. But yeah, I mean, the employer to prove that there's a bona fide requirement, those elements are listed here, but it is a higher standard to establish compared to other statutes. And the recovery is also very different, as we'll get to later on.
I think we got a couple more. One more for you under the FMLA.
Yeah, and the FMLA, the Family and Medical Leave Act, again, covers or requires covered employers to provide a qualifying employee with certain unpaid leave of absence. Sometimes it's for their own serious medical condition, but that's not the only category. It also applies to someone else's serious medical condition. It can apply in the military context if you have a loved one that is going on orders, for example. But it does protect at least 12 weeks of unpaid job protected leave for a 12-month period. There is a requirement for a certain amount of hours that they've worked during that 12-month period. But yeah, I mean, it's a pretty important statute, especially, historically, if someone had paternity leave or maternity leave, they would use FMLA for something like that. But there's comparable state law protections that we'll get to later on. But the misnomer here, or one of the things that my clients get confused, is that this is unpaid. Okay, while it does protect you and your job for a period of time, unfortunately, unless you have another benefit that can compensate you, FMLA is unpaid leave.
Thank you. Touch real briefly on the Fair Labor Standards Act. We could probably fill hours talking about the FLSA. But the Fair Labor Standard Act, enacts a minimum wage, which is still shockingly for those of us in New York is actually only $7.25 an hour. Obviously, New York's is much higher than that. But protects workers from not being paid overtime, things of that nature. Where I see the majority of these claims arising, usually in misclassification cases where you talk about exempt versus non-exempt. A lot of employers will throw that title on somebody as exempt, and then they end up, they're working 60 hours a week. And sometimes the employees think it's great. They're like, yeah, I'm exempt. It's cool. I'm working 60 hours a week. But, they're licking stamps. I literally had that case. So, you throw the title on there and then lo and behold, they're working hundreds and hundreds of hours that they're not getting paid for. You do see some of the minimum wages not actually paying them for the hours that they actually work. I see that, I think, a lot more with small employers that have very little employment background, as well as I think a very troubling area, and we all know the definitions shift constantly, but the independent contractor versus the employee analysis, and saying that, well, Glen's just my independent contractor, I don't have to pay him minimum wage. And that is a ripe area for litigation and quite frankly rather fun in my opinion, but not necessarily for the clients. And then lastly, really just poor record keeping as well. I think when you have employers that just aren't keeping track of the records or the hours that they work, but the employee is, and if they are working late, you have to pay them for that. You can discipline them and say, hey, listen, you're only authorized to work 40 hours a week, but if they're working over 40, you got to pay that overtime there. Also touch upon briefly what is probably the most famous of what we deal with here at Tully Rinckey, USERRA, the Uniform Services Employment and Reemployment Rights Act, which really protects civilian employment. Veterans in the workforce who are called to reserve duty. There's a lot of benefits that are protected by this, including seniority rights, health benefits, pension benefits, you name it. Prohibits discrimination, but it also prohibits retaliation, which I think is probably a little more ripe when somebody has to go on military service for an extended period of time. They come back and they find out that their job has either been demoted or they've been kind of pushed into Glen's corner there unfairly. There's a lot of different agencies in which you can file USERRA claims. You can do the administrative route with Dole Vets. The Department of Labor has this vets arm that does kind of quasi investigations / mediations. My opinion, there's not a whole lot of teeth to it. Have you ever dealt with a claim from Dole Vets?
No.
Yeah. So most employers are shocked when that happens. For federal employees, you can file with the Merit Systems Protection Board. State employees, you can file lawsuits in state court. And then private employers, you can always file in district court. Again, there's a lot more that goes into the USERRA claims, but they're rather prevalent. And to the earlier comments from Glen, I find a lot of employers just don't know when they get themselves in trouble with that. They're shocked to find out that they violated some sort of law there, and they've just kind of walked into it. I mean, what do you mean I had to keep this job? Well, there's a law on that one.
Yeah, my experience in USERRA is if I've had 10 claims, 30 years, they're all in federal court claims, and I can honestly tell you that of probably at the 10 of 10, or maybe certainly 9 of 10, the employer honestly was not aware, did not mean to not appreciate and protect rights. They just didn't know.
I've seen some that have thrown parades and thought they were doing the right thing and just walked smack into it.
Yeah, me too. And it's just I think that is the one where I get mostly is the really holy crap. I need to, and and the truth is, as everyone knows, it's illegal. In age, race, creed, color. Those are, they've been around for so long, but military rights, reservist rights, USERRA, it is I find that, it's a lack of knowledge and appreciation. And, when a guy or gal goes away for reserve duty and not kind of holding the job, that's just, to an employer, it's like, well, have someone run the machine. I get it. but there's a real lack of intent, but intent is irrelevant. I mean, you don't get the protections, you don't violate the statute.
Yep. And I think the other one, and this is where some of them get tripped up, a lot of military orders, types of orders. We don't have to get into the specifics, but going to Afghanistan and fighting in a foxhole is just as covered as going over to Stratton Air Force Base and doing your drill duty and stuff like that. So you may still see the employee driving around town. You go, what the heck? Well, he's on military orders the whole time. You still got to hold that job. That one I've seen more than a fair, not specific to Stratton, but more than enough times. All right. As you pointed out earlier, we do want to shift over to the real meat of this. I want to touch briefly on some of the differences on New York State laws. You pointed out, Glenn, there's a lot of better protections, for lack of a better word, or at least broader definitions as to what's covered from a discrimination standpoint. Feel free to take your things. Well, we touched on disability, right?
Yeah.
Tell me a little bit about this.
Well, let's start with the state, right? Because, it is, and it wasn't a joke before. I was really saying, I don't know why, when I first started doing this in 1989, it was all about Title VII, and that's where it was, human rights was still, a little bit in its infancy. It was kind of growing. And then kind of overnight, New York State human rights law took whatever there was with federal age, race, creed, color, disability. It basically gave, they gave better definitions. They gave stronger protections for those protected classifications. They added classifications, in terms of they made more protected classifications. Then not to kind of go a little bit off sidetrack, because I think it's a later slide. Quite frankly, there's a very different damage, exposure, between state and federal. And, kind of just, more of a strategy, which is kind of outside the mediation side of, what do you go to the EEOC or do you go to the Division of Human Rights? Because one, deals with feds, one deals with states. So there's strategic decisions.
Well, I think to that point, at least with the EEOC, you've got a shot, one in about 10 million that they'll take the case. And at least with the Human Rights Division, it might be 1 in 1,000 that'll go to a hearing. And I think in general, the evidentiary standards are a lot more flexible. I had a hearing once. I think the judge accepted my client's testimony that he had an IEP in high school. And so she accepted that for purposes of establishing disability. I was kind of shocked I got that one by, but it's administrative. It's much more informal, but you're right. That does kind of come into play as to where you want to file your claims.
The other thing for claims, not to go too sideways here, but, and Linda, I play the cards I'm dealt, so I don't ever have to make that decision. And I'm glad smart guys like you and Alan have to do that. Is, you go to the division, the division will issue cause or no cause, right? And the EEOC won't. The EEOC will say, what, all we know is we're giving you a right to sue letter. We're not saying the employer did anything right, not saying the employer did anything wrong, but if you really feel strongly about this, you got 90 days to go to federal court. See you later, sucker, right? But at least, because I'll take the division finding. And how many times can I talk about that in cases, in opening statements, and in cross-examination, or even depositions? The EEOC doesn't give you that. So but then again, if you have, personally, if I had a weak case, I'd probably go to the EEOC because they're not going to do it, right? The division, if I had a weak case, division might, stick it to me and tell me I got a weak case. And I'm getting kind of a nice little, where they capitalize no probable cause.
Oh, they do.
Letter. I
think it's extrable.
It's extrable. It's getting bigger now.
Bigger every time.
Nice. I like, because old guys like me can now read that, right? but again, it's just that, without kind of getting, look at, there's a, state law, human rights law has expanded the protections, has expanded the definitions. More people are disabled under state law than they are in federal law. The remedies, quite frankly, from the plaintiff's perspective, are richer. And it's why it's higher stakes for me to defend a human rights law claim than it is to a federal claim.
Yep. No, I agree. And we see a couple of these others here. We got definitions like familial status, which you're not seeing on the Title VII claims, things of that nature. which really, extends to families and things of that nature. We've had sex and gender for long before the Bostock decision there, and before we, talked about it on the federal level. New York was great, and I dealt with that for 10, 15 years before we ever had to deal with any of these Supreme Court decisions. So you have these added protections there. I love the next one. Criminal status. This one's just absolutely wonderful. And it can actually, I've had shockingly a lot of cases over the years that have involved this. But when an employer looks at an employee's criminal status and then just, without even going through any kind of determination, makes a decision, usually not to hire. That's where I think we see them come up. But there's a balancing test that goes into play, and there's a question as to whether or not it has a bearing on their job duties. And I've seen employers say, no, it has no bearing on his job duties. And then they move on to the balancing, and you go, wait a minute, you skipped a step. You just said it had no bearing on their job duties. And I get it. You're convicted of embezzlement. The local bank could probably not hire you, but, it's kind of a fun one, as sick as that might sound from a legal perspective.
Yeah, the obligation too for, it's just not, it's a landmine for employers, because when employers do a background check, or wherever we are, we're in the city or the state, and we're allowed to, now it's, where we need to make an offer contingent on satisfactory passing of a background check. They say criminal, and they say, well, let me tell you this, and don't get me wrong, I'll defend it if asked, but if somebody got into a bar fight at age 19 when they were in college in central New York and punched somebody in the face and maybe took a misdemeanor because they were scared crapless to tell their parents, and they probably could have gotten out of it, and they took that, and then now they're 27 and they're applying for the bank job, I think that has zero bearing. Yeah, enough time has passed, but when an employer looks at these things, there's these 7 or 8 factors in what corrections law.
Yep.
And it says, look at these things, and it's from how long ago did it happen? How is it connected to a job? Now look at, raping of a child. I don't care if it was 45 years ago. I'm not putting you in a daycare center. Okay. Molesting of a patient or someone other, under kind of, very, sensitive needs. I'm not putting you in a hospital. I'm just not doing it, and I have I represent a large, international cleaning service, and look, you'd be surprised, but a lot of people who clean buildings at night aren't they didn't go to Harvard. Okay. And they've had some tough times, and they're cleaning buildings because they're trying to make go of it. We're very flexible, except for theft. Exactly, because you're walking around Boscov and you've seen all this cool crap hanging up there, and by the way, that's an actual important case. And it's just, but there's 7 factors, and they're weird. Some of them you got to scratch your head, what that means. But
yeah, I'm still not sure the certificate of disabilities, what that gets.
I've got them.
I've got them too. I get them.
Yeah.
And I say, oh, my client has one. I don't know how that changes the equation.
Because if it, because those you can get, and there's a
Judge, I mean, how hard is it if I came to you and said, hey, I need a certificate of relief of civil disabilities? You get an attorney who puts a package together. Hey, just got one approved for Glenn.
Yeah, no, I did. That's why I'm here. Hey, look at no ankle bracelets tonight. I'm happy.
I already gave one.
There you go. There you go. I think I saw another one, and it's probably one of your clients. I had a potential client come to me on his 3rd D-Week, and he was a driver, and he was pissed that his employer was firing him. And I'm looking at him going, this is not a case I'm going to take. I would have fired you after the first D-Week. God, they were good, and they gave him all the way to the 3rd one. God help.
Yeah, those are another easy one too. You're commercial trucking, because you're in construction or delivery. Look, someone who's who might have the demons in their closet and can't kind of shake alcohol, certainly alcohol trash, and they're going, you can't put them in there. Even if a good lawyer is going to come up and make a case, a good employer is going to say, you know what, I'm not putting that person in a truck because I'm not responsible.
Yeah, liability alone might be better to pay for the damage if they're. All right, I know we got a couple more here. We talked already. We joked earlier. 3 out of the 4 of us are probably covered, at least under New York, over the age of 18. Everybody up here is covered. I haven't seen a lot with this one. It's kind of an odd one, but
Well, I'm gonna tell you, I've seen zero.
zero.
I-
Okay.
You know, it's funny that it says 18 and we all scratch our heads. There used to be a regional director of the Albany office. Nice, that would be when you asked him. And he was an ornery fellow. Hopefully he's not listening tonight. But it's like, what is it, 18? That means 4. It's okay.
It's 40. I think that's basically what we've all interpreted.
Yeah.
And then again, you're joking with the definitions in the city. Wait, and some of these characteristics here, can be protected down. By lack of hair, actually. It's more technical.
No. You need to braid, put some
okay.
flavor to it.
I could probably get, although I don't know if I have enough to do that.
Should let it grow.
All right. We've already kind of gone over some of the recent stuff, whistleblower violations. This is kind of a fun one here, and that is, labor law 740. I think I've actually been on other sides of this one in the past. This is your, employee who discloses some sort of violation of law, rule, or regulation. But New York has a very kind of specific definition, and there's two. We kind of leave alone the medical side of things because that gets a lot more specific. But the general 740 that comes into this, I see these requests all the time. And I think it's an area that is getting more and more attention, although understanding what constitutes a violation, where, quite frankly, Glenn, from an employer standpoint, you have a lot better ability to kind of be the plaintiff's attorney up on this based on the definitions. It just, in my opinion.
Yeah, and you know what else, a benefit the employers have is, so, when 740 first came out decades ago, you had to have, the presence of, imminent injury or death. It was the person saying, hey boss, just bribe the crane official, and that crane has a big crack in it, and it's gonna come down and thump all these people in the head of New York City and kill a city block. And you say, get out of here, operating engineer, Mr. Union member, you're not wanted on this job. That's really what it took. And I remember our friends Ron Dunn tried the case, remember the old Borden case at GE,
Yes.
tried to get around this, expand it, and he got chopped down. Well, maybe because of that, the statute kind of enlarged, to deal with, a lot, softer violations. You didn't need life and limb an issue. And, you're talking about, financial improprieties and, other problems.
I like the idea of footnoting for that one.
Yeah, no,
it should be in the McKinney's or something, right?
He deserves it. I hope Ron is watching.
So again, 740 claims. We touched a little bit earlier. I think, Alan, you were talking a little bit about PFL.
Yeah, a little bit. Relatively new
Just
statute.
the distinctions between FMLA and the PFL.
Well, the big distinction is that it's paid. That's a big one. There's a cap to it, 67%. The other big distinction is it doesn't necessarily apply for your own serious condition, where the FMLA does. So those are the two big ones. The other big one is you're basically eligible immediately for PFL as opposed to FMLA. So really favorable to those that may receive the benefit. But yeah, quite different, and they could be used in conjunction.
Yeah, if everything's going smoothly, kind of the charm of PFL, ignoring the burden it creates on employers because I got to have job protected leave. At least I'm not paying for it. It's insurance. I mean, it's part of your comp policy or disability. It's an add-on to one. I guess your disability side nowadays, but it's, you're paying for it, and it's, and truly it's pennies.
It is pennies on the dollar.
It is. I mean, you'll see, most employers they're allowed to take it out of your paycheck. Most employers don't even do it because it's so minimal. And it's just, but it's a rider on their policy, and it is. Now, again, the disruption, my employers, we don't care that you're getting the money. It's great. It's just, but we do, are a little frustrated that, we got to get someone to run the machine. We can't really hire someone because I can't replace you. And that's just the twist in the statute, but it is what it is. And we play by the rules.
Yep. It's one of those ones. And I've had people ask me about you, Sarah, and they say, wasn't this a pain in the ass? I go, 100%. It is, but it's still the law.
Yeah.
And you got to go with it. So I completely agree. It's one of those benefits that's out there that does come up. All right. Alan, do you want to, I know we've joked about the different types of agencies that you can file. Want to just kind of give us a very general, since you're in New York?
Yeah, and there's the EEOC, we talked about that too. It's an administrative agency at the federal level. It's really investigative in nature, if they investigate at all. So you would bring your federal law violations there, see if they do anything. If not, you get your right to sue and you can go to federal court, litigate in federal court. Another option is, we mentioned, the Division of Human Rights, where it's not really a requirement, but you can go to the Division of Human Rights, get your probable cause determination, get referred to an administrative hearing sometime 3 years after your probable cause determination.
Be kind to 3 years.
Hopefully you get a determination, which is going to be very limited because they don't like to award high damages, which may also take a few years after that hearing. And then from there, you could decide, if you lose, file an Article 78 special proceeding or potentially other options. Third option is, especially under state law, under human rights law, is bypass all of that and just go directly to state Supreme Court. You don't need to administratively exhaust that division. You don't need to do that under state law at the EEOC either. So it really comes down to your client's situation, how quickly they want to get to court, what their resources may be, especially on the plaintiff side. But those are the big 3 or 4 options you would utilize.
I am going to jump ahead a little bit because as much as we love talking about damages, I think we're going to naturally get into this with mediation. So why don't we just kind of jump ahead a little bit to mediation? And Judge, why don't you kind of give us a general overview from your perspective on the mediation process, some of the goals and benefits of mediation?
So, just generally speaking, mediation is a flexible, non-binding, confidential process where the mediator assists the parties with settlement negotiations. And mediator's objective is for participants, help the participants articulate their interests. Mediator so wants to understand the interest of the other participants. So articulating the interest of the various sides, understanding the interest of future participants, probing the strengths and weaknesses of each party's legal position. Mediator does generate, find options for mutually agreeable resolutions. Then the ambit mediator engage in what's called reality checking, lawyers and parties. Generally, mediators don't give an overall impression of the case unless all sides agree, although there's different schools within mediation, whether it be facilitation or evaluative type of mediation. Different mediators have different styles, but I typically, a lot of times the parties or lawyers will try to push you to try to basically say, what do you think? But it's a little dangerous because then they'll run to the other side and you're the only neutral in the room. So they really will use that to try to gain leverage with the other side. So,
I did it once. You keep bringing it up.
This week?
Oh,
Yeah.
no, I'm joking. And the mediator, unlike a judge or an arbitrator, doesn't have any fact-finding decision-making authority. It's the central tenet of the whole mediation process is parties' self-determination. So, very different than a judicial type of arena. Just take a look at it.
I think one of the other things, right, when we talk about the goals of mediation, we're really talking about one of the benefits, the biggest benefits to it, and that is certainty. It's trying to get to some sort of outcome, which, from a plaintiff standpoint, I'm always telling the clients, there's 2 guarantees in life, death and taxes. And then the third option is if we can actually get a resolution through mediation, and that's where you can play a large part in that.
Yeah, I mean, you get finality and certainty, and I give a pitch at the outset to the parties and the lawyers about the cost of not getting a resolution. There's time, there's money, there's emotional toll of litigation, and in that mediated context, unlike litigated context with with either a judge or a jury or an arbitrator, you get to chart your own course of mediation. Of course, you have to do it with the cooperation and consent and negotiation with the other side, but which requires compromise and good faith involvement. But you can, chart your own course, get finality and certainty, put the matter behind you and move on with your life.
I agree, and I think that's one of the biggest benefits. I want to talk, and obviously you can't speak for all mediators. That's why we select different mediators. But do you have a position ahead of times as to a preference on position statements or what the pre-mediation process for you would really look like? What do you think works towards the best result?
I prefer, I definitely like to get, almost mandated. I've had a couple that I've done on panels in state court where I haven't gotten them, even though they're required, but, it is not helpful at all. But generally, they're required by the mediator, and, the lawyers and the advocates are well served by doing it because it requires them to think and put their pen to paper, articulate their thoughts carefully in preparation for the mediation. But I also typically will ask the lawyers if they are willing to share their statements with the other side. And if there's portions that are particularly sensitive that can't be revealed for some reason, they can do a side letter to me alone. But I just think it's more efficient for the other side to know what your arguments are. Otherwise, I'm taking time to convey and articulate that in mediation, which I'm fine doing if you say you don't want to do it, but it's probably going to be a little bit longer. I may or may not be able to articulate it quite as well as you have. So I ask them to do that, and I explain why. It's up to them because it's their process, not mine.
And I'm just going to take a sidebar here. What do you two think of the confidential versus what I would call a joint statement or a public statement? We can't all say it depends every time because I agree it always depends.
My 9 out of 10 preference is I do not like to share with the other side. I think for myself it encourages a little bit more candor, and I'm not hedging. I'm willing to tell the judge that, look, I've got a difficult client. You need to be an educator in the room. And, so, yeah, and then also too, I don't mind, I'm willing to talk about strengths, weaknesses, and, another side, and I'm also sometimes willing to say some aggressive things about plaintiff or the former employee that quite frankly, I don't want anyone else reading. And, a little bit I'm trying to educate the mediator, but I'm also, I'm not there to waste anybody's time. If I have a client who's agreed to mediate, we want resolution, Bill. We're not there just to buy time to try to learn 3 little facts. I can do that in discovery in 8 seconds, right? So I like to kind of put it in there, to be more open and frank. Talk about, damages, maybe even say, look, I'd have to get rid of this in a range of X. So I just found that, and I found every mediator, and certainly, Judge McCarthy, mediation is a confidential process. If I give him a confidential document, it stays confidential. Now, sometimes, and I don't know if it was with McCarthy or somebody else, I have used the statement where I don't share, but I put exhibits in. So let me show you this email where he's, talking about, getting on with this poor young woman after work, and he's going to be waiting in the parking lot for her. I have this as an exhibit. The mediator say, a good mediator say, hey, I get you said a lot of things in there you don't want the other side saying, but can I rip off this email and show them the email? I said, yeah, it's a good email. So that's my preference. Now, I've had mediators that have said, this is an open book. Everybody, you exchange them, and I can react, but it's a different submission, and I don't think it's positive.
As you point out, right, you're posturing a little bit more. You might say, "Shit, I know Alan." Or I probably should say, "Alan is going to abuse whatever I put in here. If I give him an inch, he's going to take a mile."
Sure.
And so it does change kind of the approach as to what goes into the statement. Alan, what are your thoughts?
At a mediation a couple of weeks ago where the respondent, the defendant shared their statement. We did not. Their statement was very aggressive, and it actually sent my client off to the point where she wanted to cancel the mediation. So I didn't find it useful. Obviously, we brought her back, we went to mediation, we resolved it, all those things, but it was not beneficial. I think it depends, like everything else, depends on the parties, depends on the personalities. I don't find mediation to be an opportunity for discovery. I think at that point, we know or should know what the case is about. The parties and the advocates know what the case is about. I think the submissions are really, in my opinion, more beneficial for the mediator to understand the case a little more and to understand the strengths and weaknesses. But when it's shared, I think there's too much emotion that goes into it amongst the parties where they're already at an emotional stage to even agree to mediation because they're so diametrically opposed to their positions. They're not going to agree by saying your mediation statement. Okay, now I have an epiphany. Suddenly, you're right. I don't want to do this anymore.
You think the clients are just going to be bamboozled by Glen's opening and they say, you know what, you're right, I just give up.
That's the next one, openings.
I was going to go to openings next.
Kind of connected to the same, like the same purpose of, you get a statement from someone, and I don't know if they were, an EPLI lawyer or a traditional defense lawyer or a traditional employment defense lawyer. I mean, mediators aren't stupid, right? I mean, and if you come out guns blazing, I think it's a bad. I think it's a bad move for the plaintiff too. I mean, I've never had woman treated more poorly than this, and this guy's disgusting. I think it sets the mediation process back. I mean, to your point, look, there's no discovery in mediation. I mean, it's just. If it's really super early, maybe you learn a few things, but you learn them so quick elsewhere. I don't know. You're there to resolve it, and in resolution, let's be honest. If it's at that point, it's money.
I will say that if it's pre-litigation mediation, it might be useful at that point because it's so early. Like you don't really know what the case is about. But when you're in the process, you're in litigation. You're probably in discovery already or beginning of discovery. I don't find it beneficial to do that. And to your point on opening statements, I usually don't recommend my clients to do that. Sometimes they just want to tell their story. They want to be heard, and that's an opportunity for them. But you're assessing their credibility. My client may not be credible. So I may not want that, right? I think it depends on the situation. I think at that point, when we agree to mediation, we know each other's positions, our legal positions. We probably know each other's kind of settlement posture at that point as well. We just need someone like the judge to come in and help us get to that point of resolution, and really just to maybe even separate us into different rooms immediately and have that discussion. But I think every mediation can be very different, and I think a lot of that is the variables that are involved.
Yeah, those are good points, and that's why generally the default rules that they're not shared, and they're, the other thing that's important is it is self-determination. So if I call and suggest it, the lawyers say no, then that's the end of it, and we do it, the way it's typically done. And I have had the experience that you just recounted as well, where people wanted to light their hair on fire when they read the other side statement. So where it's gone off the rails. So that can be a problem.
Judge, in your mediation world, do you get more pre-suit mediation, post-filing mediation, or mandatory mediation?
More post-filing than pre-suit, and a mix of mandatory.
Let me ask you this. Have you ever, I think we've all seen the pitfalls of an opening statement setting things sideways. And you've seen a lot more mediations than I have. Have you ever seen an opening statement from any attorney that's actually, Alan Dershowitz all of a sudden alters the course by his opening statement? Has there ever been a benefit, or have you ever seen one that just completely altered
maybe
the
once or
mediation?
twice, but 1 or 2% of the time.
Right.
And I explain when I do the opening too. And if you're here, you think the other side's going to just fold, like they're going to, decide that they're wrong and you're right. Or, the plaintiff's going to decide the defense is right. The defense is going to decide the plaintiff's right. Case has, absolute merit or no merit. That's not going to happen. You're in the wrong room. We're here to negotiate, resolve, compromise. If you want a home run, you're in the wrong room, go to court, go to an arbitrator, go to a fact finder, and you're either going to win or lose. And then you're, maybe have an appeal and you're going to spend tens of thousands of dollars in another 2 or 3 years. And you can have certainty and finality here, but nobody walks away with the entire loaf of bread.
Yeah, no one walks away happy. That's,
Yeah.
that's a good result.
It's a good
right?
result. Yeah.
Everyone's content with the outcome. And to everyone's point, there's finality.
So much more of a Pollyanna than me. I say everybody goes home slightly angry at each other, and that's usually a good outcome.
Yeah, when they're walking to the elevator, no one's talking, that means you settle the
You
case.
did well. Yeah, you did well at that point. I wanted to talk a little bit about something that Glenn touched upon, and that was the strengths and weaknesses of the case. How much as a mediator, obviously, so we're still talking pre-mediation here. You get Glenn's position statement, you get Alan's position statement, they give you their version of events. How much independent analysis do you like to do? And again, we're just talking about your preference on evaluating, doing your own independent assessment on the strengths and weaknesses and where you are planning on pushing or pulling.
Yeah, I mean, I think it's a very important component for the mediator to engage in that process of, analyzing the facts, the law, and having an opinion on strengths and weaknesses, and then discussing it with the attorney and their client when you do caucus. And, kind of more softer by asking questions about the weaknesses, but framing them as questions like, just, are you concerned about this, or how is that going to impact your case? And they know what you're doing. So just, getting them and their client, a lot of it is managing client expectations too. And the lawyers need to tee their clients up about the process. Some do, some don't. If they don't, it can be, fall largely on the mediator there, which is, can be, sometimes more difficult than others. But the front end of a case is typically the lawyers telling the client how they hope things are going to go. Cases rarely go exactly as you want them to go. So sometime between the start and when you get to a mediation, there should be a conversation about, what has transpired in the case. And now maybe things don't look exactly as we had thought on the front end. So we have a little different position today than we thought we might be in. And, it may require us to yield a little bit more, be more flexible, more willing to negotiate good faith.
What about, talk a little bit about, again, pre-mediation, just pre-session, do you do independent calls? I think most mediators always do some sort of group call to get their rules, and sometimes it's just the attorneys. Hey, this is what I want. This is the timeline. This is what we're looking at. Do you go into more depth? I've certainly been in mediations in the past where mediators will even do a short half-hour conversation ahead of time after getting the position statement, just to understand the facts. Hey, Mr. Macomber, you said X, Y, and Z. What the heck are you talking about over here?
Yeah, I mean, it depends on the case, but, in some cases are really simple and don't require it. But if after reviewing the submissions and the exhibits and everything else, if there's questions or concerns, I will typically reach out to the attorneys and have some conversations with them in advance. And I'll do it individually too. It's not always, I can do it with one side just to have clarification and get some and have also ask, is there any special issues that I should be aware of? These people hate each other. Should we even put them in the same room? What's your view on opening statements? Typically don't find them helpful, but do you have a different position? It is their process.
Yeah.
So I'm not the boss there. I'm just there to facilitate. So I try to get input on almost everything.
You, both Glenn and Alan, you both brought up the question or issue of client control, and what from a pre-mediation, we'll switch to the mediation itself shortly. What do you see as being beneficial prior to the mediation to kind of set expectations or to try and help control the client a little bit before you even get in the room? Alan, do you want to go first?
I think that conversation occurs throughout the representation of that client. So I think you always need to tell them what the risks and detriments may be for their case. what the strengths are as well, what their damages may look like, how much it costs to litigate, all the same things that you said, Judge. We do that all the time here. I know I do it. But once we agree to mediation, I think it's really helpful to have them understand that we're going into this. You're not going to get everything that you want. You're probably not going to get most of what you want. You're going to probably get some of what you want. And it's important to keep an open mind. Don't walk away just because you feel that this is a waste of time. Don't walk away because you don't like what you're hearing. Just keep an open mind, let the process happen. If it doesn't resolve, you just go back to where you were before. Go through the process. I find it very useful to have those pre-mediation calls with the mediator, with my client there. I want them to get comfortable and acclimated with the person who's going to help them through that process. I think that initial introduction, I think, is very important to kind of get a sense of that personality and the neutral. And again, it's their process, so I want them to feel comfortable with it. So I regularly communicate with them throughout about mediation, what the values are of mediation, who the mediator is, who the other side is, what to expect, who knows what's going to happen. Just keep an open mind that, the point of it, in my opinion, of mediation is everyone may disagree, the parties disagree, but we're all agreeing to come into this process to hopefully resolve the issue. And that's some commonality that we have. And, just keep an open mind because we're all there for the same reason.
I like that.
I had something brilliant to say, but Alan's voice is so soothing that I just kind of started to drift off and start thinking about other things.
It's when you sleep.
It is. No, it's not funny to sleep. It's soothing. It's therapeutic. But no, this is kind of, I'll go sideways on this a little bit. I've had mediation with your firm, and you folks bring your clients in reasonable, even keeled, and you're prepared, and I can tell. But that's not the same for a lot of other plaintiffs' firms, and I think that it's problematic because Judge, when I come into your mediation room, truly, I don't mind a little storytelling. I don't mind, I don't even mind buying everybody lunch. But I want to get the heck out of there at 1 o'clock, and I want to start doing other things, and I want to resolve that case. And when a lawyer or both lawyers, needs you to do too much client educating in terms of creating expectations, I think that really craps out of mediation. So I work hard on my folks, when we go to mediation, kind of reasonable expectations, best case, worst case, here's what we'll do. And I know you folks do the same. And I think that is essential to have an effective mediation. And again, if you're relying on it, if you come in a room, Bill, you're there, and you want to cause mediation, that's why we brought you in. You're neutral, you've got, all that, you got that old judge badge, you get to talk that, and, you get to tell some stories, and everybody walks in and say, oh my God, he's great. And I want that. That's the forum that I want. But if I'm leaning on you, hey, by the way, my clients are a little bit kind of wacky in the head, I need you to kind of get them into orbit and let them know about risk. It really takes a lot out of you, and it takes away from the process. So one of the things I see that and again, 8 out of 10 are good for me. But every once in a while, I get to play as this lawyer. A lot of them from New York City at this point in time too, and I'm like, what the heck? I mean, why didn't you kind of beat your client up a little before you got here? Because now you're making this mediator, and he or she just doesn't want to do that. I can tell. So that's mine.
I completely agree with that. And I do think when you get a employer's attorney that doesn't understand it, like you said, you and I, if we're having a case, by the time we get to mediation, we've got the issue narrowed down to maybe one issue, hey, did we really engage in the interactive process? We put all the other crap aside. And so you're getting to the heart of the issue. What is the most painful thing on earth for me is when you go to it and you're having to educate your opponent. And those are the ones where they come in and it's like, right, when the law is on your side, you pound the law. When the facts are on your side, you pound the facts. When neither one's on the side, you just pound the table and you make a fool out of yourself. I've seen that approach, and it never ends well. It never ends well. And then it's honestly the only time I entertain really opening statements is when you feel like you almost have to speak past the attorney to educate their client a little bit of, hey, this is a risk. I had a case years ago down in the Eastern District of Virginia, which is a rocket docket. And this attorney, we're going to win on summary judgment. And there's just no way. And we spent 12 hours in this mediation. And finally at 6 o'clock, there's a magistrate. He pulls us in. He's like, I got my daughter's volleyball game in a half hour. If you don't go in the other room and either settle it or don't, I don't care. And it came down to $10,000. We got the extra $10,000 and all went home unhappy. But it's so frustrating when you feel like the other side's not fair. Whether it's our side or the employer's side, doesn't matter.
I think it's unfair to the mediator too, because
100%.
The mediator has I think a very pointed job in that room, right? And it's to, parties that voluntarily agreed, they've signed your confidentiality, thing, agreed to pay, we agreed to share expenses. Look, again, lawyers should be going in there with their clients because they want to resolve the case. I mean, and if one of the issues needs to be a, judge, when you got to kind of educate my client here a little. It really craps up the process, and
Unfortunately, it happens more frequently than I wish.
I can only imagine, and at least in our in I think the employment context, I think most people that are going to come into your room, I think they either defend a lot of cases or they prosecute or plaintiff a lot of cases. So I think it's good. The worst cases, and I've seen this and I've heard stories, commercial litigators, right? It's like they're all over the place. I mean, they're still worried about, theories and, damages. It's like, you got to be kidding me. I mean, at least we know, and we kind of went quick through the damages, I mean, look, you can go in there and you can calculate your best, ignoring compensatory damages. You know where it's going to go, and then we can talk about risk and and let the judge kind of weigh in on that. So, but I think that it's easier for us, but still I see failures, and it's like, Jesus, you're killing me.
I love, and we'll touch briefly upon damages. Alan will attest to this. I love nothing more than sitting down and calculating damages, because to me, it is a simple math problem. You get ranges, fine, comp damages, is it 50, is it 150? Like, okay, we can move around in those windows a little bit. But you give me a wage and hour claim, that's an Excel file. That's not like, you're not doing anything complicated at that point in time. And going into a mediation prepared with your damages, knowing to a T what you're going to be able to get, is so beneficial, because I've seen so many times where people come in asking for the moon, and you're just like, we're never going to get there. The law doesn't even provide for this. And you go to crazy town. I had years ago a deposition that went 12 hours of nonsense, of you objecting to me objecting to you, and all kinds of malarkey. The next day we had mandatory mediation. In that 10 hours, they never asked my client a single question about damages. Do you know what our damages were? I can't say what we settled that for the next day, but it was a lot more than zero. So you got to know your damages. And I think a good, whether it's position statements or whether, and I'm going to move a little bit over to during mediation, but having the parties understand that. And I think it's an area as a mediator that you can poke a little more. Like I touched upon the compensatory damages, right? Who knows what's going to happen with that? You go to a hearing, you go to a jury someday, you could see zero, you could see $5, you could see 100,000. But I think it's an interesting area to, as a mediator, you can really start kind of poking your finger at and saying, have you thought about?
Right. And it's either that, what you just described, 0, 50, 100, 300, or some finality where you have some input in it today. The other side, so it's going to be a compromise, but that's the whole pitch to them. But like I think what you said is important as well. Good lawyers will have their best day, their worst day, and then so the window within which you're operating in, and then you got a window within which to negotiate. But with the understanding that you're not going to get your highest and best value on a settlement either. People need to understand that as well. If you want, your the full value, you're probably going to have to go to the distance.
Oh, yeah. And I think that's a valid point. You know, you want to risk it all. It's a zero or nothing, or, you know,
Right.
all or nothing game at that point in time. Here's a fun sidebar, the Rule 68 and how that plays in the federal process. I don't remember if it was you. There was someone who gave me a Rule 68 that was literally $2,500 off my number. And I was blown away. And I was like,
I hope to
holy.
God it wasn't me.
But I
I'm
was,
Mr. Rule 68.
it's a great tool. But when used right? You come out with $10,000 and we're freaking 2 years deep in federal court. It's not going to work.
Yeah, well, you know, I mean, just to throw it out there, you want to spend 30 seconds on what a Rule
Yeah.
68 does?
Yeah. So if, you know, the defendant in a federal case, when you're in federal court, issues an offer, is it technically offer of
Offer of
compromise?
judgment.
Offer of judgment. Thank you. So under the federal rules of civil procedure, if they offer you an offer of judgment and you do not recover more at a trial, it precludes the ability to recover attorney's fees, which from a plaintiff's attorney can sometimes be substantially larger than even the damages alone. So when I sit there with a client and they're looking at, and we haven't touched upon this with damages, one of the huge components in the employment arena is the shifting of attorney's fees for a prevailing party. And I know that motivates Glen's side when they're going, oh crap, not only do I have to pay him, I might have to pay Alan too. When used appropriately and at the right time, it can put a plaintiff's attorney really in their place to say, ooh, crap, I valued your case at $100,000 and he just did a Rule 68 at 90. If we don't hit on all these cylinders, we might lose attorney's fees at that point in time. And that can be very problematic.
There is also, which, you know, is in one of my letters that I've sent to, you know, my brothers and sisters around the state on this, there is law from the circuits and actually hinted at by the Supreme Court in a case called Ford Motor Company that says not only do you not get your attorney's fees if you don't hit the delta, but you pay mine.
Yep.
Because I'm a prevailing party now off that offer of judgment.
Does that one work in New York?
Yeah. Well, let me tell you, it works when I raise it.
It works when you raise it in settlement.
Mediation, the mediator says, oh yeah, I've heard of that.
No, they haven't. I was gonna say, I don't know.
No.
But I think I have seen it in other circuits. It's a great tool. And we touched a little bit upon the time to initiate. And I think this is a good segue as well. When used appropriately at the right time, it can be very effective. Let's touch a little bit upon timing of mediation, because I think that is very important as well. You talked about pre-suit. You said most of the mediations you see are post-suit. And start with you, Judge, and we'll go right down the row. What's your thought as to what is the best time to engage in mediation? And we can't all just say it depends, because we all agree on that.
Well, I mean, one component that's very important is that the parties have the information that they need in order to make a decision. I've been at a table several times where, you know, we come to a point where somebody realizes there's some piece of information that they need that they don't have, that you know, they really can't resolve the case without that. So we end up adjourning, and you know, the can gets kicked down the road. So I mean, the parties, the lawyers have to be proactive in preparing, not only on their own side but the other side, and make sure, in case the other side isn't necessarily on top of everything, everyone's busy, is there something that the other side's going to ask me for in the mediation to provide them with the other side, either the principal or attorney, in order for them to be able to make a decision on how this case could get resolved today. So, I mean, part of it is just, do you have all the pieces that you need in order to make a decision on how best to come to an agreement?
I like that. Glenn, what's your thoughts?
Well, I don't know. I think related to what the judge talked about too is I think, you know, I mean, you always bring a decision maker with you because you're a plaintiff, right? I think with the defendants, and I always try real hard, and I come, either I have the owner run really close to it, or I have a general counsel and you know, the CEO on a call. I think that, you know, a big problem is too, and I think this is more your issue that you guys got to work out. You're bringing a decision maker to this mediation. because I'm not playing, you know, phone tag, and I'm not saying I'm going to get back to you. I think that, you know, I think it's disrespectful to the process if I did not bring a decision maker into the process, you know, somebody who has to check, or the ability to reinstate if that's what's on the table. So that's my, you know, and I'm aware of situations, you know, from my brothers and sisters who do what I do, and sometimes you bring in, you know, the plant manager who has as much authority as you know, as my lab retriever, and it's just it's not effective, because, you know, if he or she's got to keep getting their phone, that's just silly. So my pet peeve is, Alan, what do you got?
I think the best time is anytime, honestly. I think a lot of our plaintiff clients, they want a resolution as quickly as possible at the most cost-effective means possible. Doesn't mean that it should happen immediately. To the judge's point, sometimes I think it is helpful to have the information, and both sides to have that information. I think another consideration is if there's a carrier, right, involved, and you know, at different stages, their adjuster may be willing to pay different amounts. And, you know, again, it depends if my client's looking for a financial outcome, or they're just looking for some modifications in their work environment, right? Something easy that you and I should be able to agree upon in just one phone call, but we don't. We need a mediator, and we go to mediation. But I do truly believe, I think mediation is valuable at any stage, whether it's pre-suit, during suit, after summary judgment, right before trial. I think it's most of my cases settled because of mediation. And I think it's valuable for really any stage.
Yeah, I've had a lot of, you know, my recent year in mediation has been pre-suit.
Yeah.
Yeah, and they are genuinely sensitive cases.
Explain a little bit about just how a pre-suit case would come up.
Pre-suit cases, as my client typically gets a letter from Tully Rinckey or some other firm that says we represent current employee X or former employee Y, and you know, they've retained us and we've reviewed it and we got some big problems. You know, he or she made a harassment complaint, was ignored, and you get some kind of letter like that, and it says, you know, it's like, look, these are sensitive allegations. They're sensitive to us too. We're gonna be honest with you. We would prefer, you know, our client not to have to kind of be publicly talking about, you know, being assaulted or something. And it's very obviously, you know, the employer shouldn't, you know, want that. Even if it's false, I mean, you know, what good is it? You know, the articles hit the Times Union, right?
It's out. You know, that's what they remember.
Right. And you know, then we went on either judgment or verdict in 18 months, big deal, right? So, but that's how that case sets up for me. And typically, sometimes, you know, this is big right in New York City, to be honest with you. You know, and they're coming up the river. The plaintiff's lawyers are coming up. And, you know, a lot of them are, you know, do you want to engage in pre-suit discovery? I mean, there's a firm in freaking New Hampshire that's their standard letter. Of course, they use the same letter for every demand.
Love that.
You know, and I know you know what I'm talking about, but I don't get that one. But the good lawyers will say, you know, look, you know, there's an interest in both parties, I assume. You know, do you want to get together? And quite frankly, the answer is often yes.
I think the point you really hit there is both sides need to be ready. Wherever the time is on the equation, and sometimes it's pre-suit, and when both sides are ready to come to the table and have some sort of compromise, that's the best time, and it's really the only effective time that it's going to get there. Because if I'm twisting my client's arm, or you're twisting your client's arm, 9 out of 10 times those don't end well. And there are times where it's changed throughout, where I've had cases pre-suit, you do the mediation, pre-discovery, post-discovery, post-summary judgment, and then guess what? Pre-hearing, you know, pre-trial submissions getting submitted, and now it finally settles. But nobody was ready before that time. Either my client was in the clouds, or the other side was being recalcitrant. You know, you both need to be prepared to come to that table. Jumping around as we tend to do, which we knew was going to happen there today. Let's talk a little bit about just kind of from both the plaintiff's perspective and the defendant's perspective. What is that real motivation at getting that case resolved? You know, Judge, you talked about, right, everybody's got to give up something there at that point in time. But what do you, Alan, start with you and this way. What do you find is, the best way to understanding that employee's motivation early on?
Really what they're looking for as an outcome in their case. I mean, yeah, we do have clients that are just looking for a check, right? See it as a lottery ticket and, there's a financial component to it. There are some that are really genuinely looking for the difference in how they were treated and not really necessarily on how they were treated, but, more of a principled reason as to they don't want this happening to someone else again. And then I tell them, you need to kind of think about yourself and, employers are going to violate the law. These laws have been codified for decades and unfortunately the violations happen every day. But I think really, I hate saying it depends, but, it's true. I mean, the plaintiff's motivations differ at different stages in their case. I think in the very beginning, sometimes they were just subject to some adverse employment action and they want that to be undone in the very beginning. I think as time goes on, they kind of dig in their heels. They want more and more and more and more. And if they're paying their attorney, at a certain point that's going to break, right? And they, financially aren't able to continue on. And so now they're willing to come to the table. To the extent it's a different arrangement, I think they dig in their heels, and the longer it goes on, the more emotional it gets and the more they want, which is again why I think it's important to kind of hit that head on and try to resolve cases early on, because I think it's beneficial for everybody because it doesn't get better over time. And what my clients sometimes don't understand is they can't recover for that, right? Like, if this case goes on for 5 years and, now you're unhappy that's going on for 5 years and you have all this pain and suffering that's happened for 5 years. That doesn't mean you're going to recover that pain and suffering for that 5 years. You're really looking at the action that happened, damages that happened as a result of that action, and some corrective action that you can get as a result of that. Mediation helps with that. Again, you're not really going to get all of that, but at least, you come to the table trying to get a resolution, hearing it from the other side, even if they dispute it, and even if they say what they're going to say, and it's a no-fault resolution, depending on what they give you, you kind of have to read the tea leaves too. And, if they're willing to throw you a 6-figure check, you got to kind of read into that. They kind of, the employer understands there's some risk and liability there. And I think, in that component, going into mediation as well, I tell my clients that, yes, the other side's going to disagree with our position, but I think you also have to assume your position's going to be established and really talking about resolution and what that relief looks like. And again, the longer it goes, the more difficult it is sometimes for my clients to be willing to take less.
Well, I'll come right back to you. I think that emotional component from the plaintiff's perspective is probably one of the hardest components to deal with, because ultimately, at the end of the day, we're talking about damages. We're talking about money. And for somebody that is emotionally harmed, it is the hardest thing. I can count on one hand the number of times I've gotten an apology letter from an employer, and it doesn't change anything. If an employee was sexually assaulted or sexually harassed, that event is never going to go away. And at the end of the day, it could be the biggest check. It doesn't change the fact that that emotional component is always going to exist there. That can be extremely difficult.
Yeah, that's why the motivations change, right? And really, you can't undo what's been done, right? You just try to make it right to the extent that it could be made right. But that closure really happens from within. And there's no amount of check or resolution or judgment that's going to fix that. And a lot of my clients tend to understand that over time, but a lot of them don't. And it just gets worse and worse and worse the longer the process goes on.
Glenn?
I think that I think this is, one area and, in mediation or settlement in general, where it's typically a little bit easier to bring an employer along than it is a plaintiff. I mean, don't get me wrong, in 30 years, I have had, millions for defense clients. Okay. It's that no good Nick, and I'm going to show him or her. Okay. I've had those, but more often than not, I quickly get into, look, it's a business decision. It's a cost of doing business. I get it. The allegations are BS. Okay, all good. But do you want to move forward, make more widgets and make more money? And because if you want to spend a lot of time with me, I appreciate that because we charge you a lot of money and that's perfect. But if you don't want to spend time with me and you want to move on, there is a resolution possible. So I think that, I'm not taking an emotional shot at plaintiffs, but I think employers, have the, kind of the gift to kind of, get more to it, say, okay, I just got to be done with this thing because it's taken too much points off the board. I mean, I need to run this company. I need to sell more paint or whatever the answer is. I think it's a little advantage at this point. We're kind of channeling the expectations and the demands and the reasonableness.
And from a timing perspective too, having a plaintiff's attorney understanding the other side of that equation. If I've served, God knows how many requests for ESI and you're hiring experts to do forensic searches of computers and laptops and all this stuff, your client's probably pot committed at that point. And they're saying, we've just paid $100,000 in discovery costs. We might want to roll the dice for another 50,000 for a trial or something like that, as opposed to if you go in at the right time and know what the other side's, pressure points might be. You say, hey, before we get into 25 depositions, maybe we should sit down and think about this, because it's always the component on the employer side is, I'd like to get back to business. I'd like to, at the end of the day, they're either going to owe some amount of money or no amount of money, but that does play a large part into it. I want to talk, see, we're getting towards the end here. I want to talk a little bit about a fun one. And Judge, no, don't take any of this personally. Selecting a mediator. And, I think there's a lot of, we don't have to name names here, but we'll start with you, Alan, from a plaintiff's perspective. What do you look for in a mediator in selecting somebody? And go from there.
I look at my client first. If I need someone to tell my client basically the same thing I've been telling them, so I look for a judge who is a mediator now, who hopefully can educate them on the law and really educate them on what I've been telling my client. So I look for someone like that in that circumstance. Other times I look for a mediator that can be very aggressive with the other side. I look at, for example, I believe the NDNY list for District in New York, they actually have a list of mediators and they will tell you kind of the percentage of successful outcomes for those mediators. So sometimes I go through that list as well. But most of the time I use mediators that I've used before that I've been successful with, that I know will work well with me, well with the other side, that is reasonable, that will work well with plaintiff's attorney and plaintiff generally. So it does vary depending on the case, depending on the client, but most of the time it's someone that I've used before.
Excellent. I would wish I had that luxury. I don't. A lot of my life is down in the city now, and there's a lot of professional services, AAA jams, and everything, and there's a lot of people jumping in there. But if I just had to generically pick, okay, and for an employment case, my first pick is always go for a retired judge. Always.
Yeah.
They've got a better temperament. They can dig when they need to dig, and they're not, they've been doing this long enough. They're not going to embarrass anyone in the room. I like their temperament. I like their experience. And I also like them to talk about the days when they wore the robe. And I also like for them to be able to say, I had a case like this when I was on the bench. I think that's just, it's good for people to hear it's true. So my default is always retired judges. Okay. And then if I can't get a retired judge, or I pick, or my panel consists of lunatic retired judges, and they're out there, Bill. I'm just going to tell you, my next pick would be, an employment mediator. And I don't care if they're, quite frankly, if they did what you did or did what I did.
Yeah.
I just need, either if I can't get a judge, I want someone to at least knows the world of best cases, worst cases, and damages. I don't want somebody coming in, who's a commercial litigator or just, did a closing of a barn, up the road. to come in and tell me that garden variety pain and suffering is worth $400,000. And I'm just I'm gonna scream and say, let's just cancel it out. I need someone who knows what that answer is. I know the judges know what the answer is, and I know plaintiffs' lawyers. And even, like I said, even a plaintiff's lawyer knows, what that answer is. They've had cases of division, they've tried cases, they've seen cases, they've settled cases. So and in fact, again, retired judges that I've had poor luck, having to deal with generic commercial litigators or corporate attorneys who want to be. They all go to mediator school nowadays. I don't know what that is, but there's mediator school there. You're supposed to go in and get anointed to be a mediator. Some come out good, a lot come out awful. That's why I like judges. And if I can't get a judge, I'll take someone who does what I do on either side of the line.
I completely agree on that with the practice area, because I've seen that with, the commercial litigator who wants to try their hat at mediation. I don't know how many years ago was this. Remember when Vance Speedball State came down?
Yeah.
We had a mediation this day, and we walk in, and I think the mediator, I was a young kid back then, and I think he just wanted to rattle me. And he said, hey, Supreme Court just issued, it was 2 decisions. It was Vance, something else that came up that day. And he says, how does this change your case? And I absolutely lost it, panicked, freaked out. Spent the next 2 hours. Thankfully, we were in. I didn't cry. That doesn't happen too often. Thankfully, we were in our own office that day, and I was able to pull the cases and I'm reading them. And after 2 hours, I'm going, these have nothing to do with my case. And it was a horrible, horrible experience. And I think we can all imagine how that ended. Can you touch real briefly? It's been a couple of years for me on jams and AAA, but they typically do a panel approach, or you pick 3, I pick 3, and
You can. I mean, I can tell you what the plaintiffs' lawyers in New York City do.
Yeah.
They say, here's 3 we could live with. Pick one. If you can't, I mean, usually in a lot of like individual arbitration or mediation, you have an employment agreement. There'll be a panel strike,
Yep.
Those kind of things. It is in fact, we just picked up the judge in an upcoming arbitration in a month or so, and it was a strike situation, but that was PERP.
Oh yeah, Perp does those too.
Yeah,
Yep.
and we got 6, and of course I listed you as number 1. But no, it's so straight. But usually, and that's why, and that. There are even in New York City, there are fan favorites. And, the other thing too is, and as you go to bigger cities, there's these underground groups, be it the management lawyers, the plaintiffs lawyers.
Yeah.
And we all have super secret lists on who's a knuckleberry and who's not, right? We just do.
Yeah.
And and we share those lists and we share that information, and we're good about that, and avoid him or her because we do it. I'm sure you guys do it too.
Well, we do. We do. And go ahead.
Unfortunately, I'll tell you, there's, even in the Albany area. By the way, that Northern District list scares the bejesus out of me at times. That's why, if I can't get McCarthy to come in and do it, for mediation purposes, sometimes, I will, ask the magistrate to do it.
I completely agree with that.
I like it. I think, it's just a sidetrack, but if I can't get McCarthy or employment, my third kind of backup is if it's federal.
Yep.
I'll ask the magistrate. Quite frankly, the magistrates in Albany will do it. Okay. And both sides can agree. They'll do it. They don't have to do it, but they'll do it, and they're good at it. And I just think both sides having to walk into that sterile federal courthouse, go to the elevator, press number 3 or 4 on the button, and you go in and you meet a nice mediator and see his or her, kind of robe in the side there. It just makes everybody kind of appreciate the intensity of what's happening. And it's not fun. Mediation, it's not fun. Mediation's awful. I mean, but it's necessary, to resolve cases that people decide should be resolved.
I think the other benefit with being in the courthouse, generally they have a small army of clerks that think this is the coolest experience on earth to come watch, but the magistrates and the judges have sent them on all their little homework assignments and they come prepared. I had years ago one, and I was talking about garden variety, damages, and I see this clerk just nodding his head along, and then he pulls the judge aside or the magistrate.
Give me the bench brief now,
He
kid.
goes, yeah, Mr. Macomber's right. He can get up to about 100 grand on this on garden variety. And, but that's largely helpful because, again, unless you're dealing with somebody who has prior experience litigating employment claims, there's a lot of nuances here that we just scratched the surface on. So it can be very helpful. I think they got a lot of great resources to that. I'm not going to ask you as to how you pick your mediators, but I would ask, how do you think mediators can really set themselves apart to the likes of us three stooges as we're trying to pick a good mediator?
Well, I mean, I think follow up what Alan said. A lot of you get a lot of repeat business if you do work with lawyers or firms and they like you. They typically go back. And people told me that when you started. I mean, it takes a little bit of time to break in, but once you get going with lawyers or law firms, they reasonably happy. And it's not always because you settle the case. I mean, it's not necessarily the mediator's fault if you don't settle a case. And there's typically, at least the parties say it, and I believe it because it's in my best interest to believe it. But even when cases aren't settled, it's a productive process. The lawyers and their clients tend to learn a lot in the mediation process, even if it doesn't reach the ultimate goal of mediation, which is an enduring and binding agreement. I mean, in response to your question, though, I mean, I think being prepared is probably the best thing that you can. Being truly objective, being neutral, being prepared, maintaining confidentiality, but overall being as prepared as possible, and just trying to actively listen as well.
But Judge, I'm going to make you blush. Okay, because I've never officially used you in a mediation. I've had you in arbitrations, never had you in mediation. I will tell you what the market says about you. You get it right. That's it.
Paying them forever.
No one claims, your plaintiff's friend or a defendant's friend. No one claims that stuff. And since you've left the bench, you're making, and you're making a great impact. The only threat in the area, but honestly, the convict always comes down to he gets it right, or he gets it. And I think that's a great compliment to you. And that's how I think, Bill's practice grows or practice grows. Because I mean, there's some turds out there.
Well, there are. And to your point earlier, if you're not being fair, if he's not right down the middle, guess what? Alan and I are talking about it. And next time you suggest, there's no way you're getting that name by me versus, somebody comes to you and say, yeah, he was fair. I didn't win that case. I didn't settle that case. We didn't come to a resolution that day, but that was a productive day. And if nothing else, it was straight down the middle. And to be fair, it's a hard job. I don't think I could do it. I'm very opinionated. I want my side, and it's hard to stay straight down the middle, even if you are leaning one way or the other. Right. I mean, let me ask you that. There's sometimes I'm sure you read them and you're going, he's right, I'm wrong, but you still have to go right down the middle.
Yeah. I mean, probably you're right. I mean, just, my prior work helps a little bit because I mostly was in neutral positions most of my career as a clerk and then, judge at various levels. So that helps. And, I like trying to facilitate resolutions. And I think mediation is very effective. It's a good way to go. I really do.
I agree. Well, you mentioned one last term, and that was getting it towards finality. And I see we just have a couple minutes left, but I will agree that keeping it fair, stay in the middle, that's great. And that usually turns into that best result, which is hopefully what we all get to. And that is some sort of settlement. And I want to just briefly touch upon in the employment context, some of the high points in a settlement agreement. I mentioned before, I always want an apology letter. How many apology letters have you written in the years?
I've written you 0. That's I can say that with every other plaintiff lawyer in this country. So.
What are just some of the common terms that we typically see nowadays in settlement agreements?
Look, a lot of it is because the law has changed or backed off recently, and we're now back, heavy into confidentiality and some sort of non-disparagement. We've all pushed the envelopes on those issues with the NLRB and other, but they're all backing off, laws change, new administration. We're not worrying a lot about the feds. Still some concerns with the state of confidentiality and that, but there's ways around it. I mean, there's considerations, but I mean, those are kind of the boring, but obviously there's money. There's, I want to make sure this, I don't want to, take another claim next week. So I don't want you ever reapplying to my company again. I do want confidentiality and I want no admissions, and I just, it's like, look, I'm settling this as a business decision, as a settlement, as a resolution triggered by the mediator. That's why we're here. I'm not admitting anything. I'm not admitting liability for anything. And I'm resolving this case, and the typical confidentiality and everything else will go. And look, we'll go, we'll give a little on each side too. If we don't, employers don't need to be pigs because employees need to be, kind of, feel that, they're not getting screwed in an agreement because typically, settlements are they do read very much one-sided, right?
Oh,
we're giving you the money, you are a piece of crap. I mean,
we never want you back.
Yeah,
and you can never talk about it.
Yeah, and those are tough provisions. So, I mean, I think sometimes, the weirdest thing, and I've seen, defense lawyers dig in, and it's like, the person here at the end says, "Can I get a neutral?" Okay, a neutral reference means they worked here.
Yep. They
held a position of, tech writer 4, and they're no longer employed by this company as of April 4, 2024. That's what a neutral reference is.
Name, date, serial
And
number.
people fight it. And here's my take on that. I'd rather give you a letter, okay, signed by the highest person I can find, because truthfully, I don't want you calling the company because you're going to get some stupid soul who's going to say, "Oh, that was the guy who sued the company. Oh God, was my boss pissed?" I think no, give you the letter up front.
Take it now.
So I don't know why employers and defense lawyers dig in on that issue. I mean, I don't offer it up front, but when you ask, I'm like, "Oh, okay," like you're getting something. But that's my take on it.
Well, and you do see some of that, and I've seen those pitfalls where they do the neutral, but then they don't designate who. And I had a client who literally had a breakdown. Whatever industry he was in, he was making widgets and could no longer make widgets, and went out and got a job as a postman. And almost lost the job, because it's the federal government. It took him a year to do the stupid background check. So he's been doing the job, happy for a year, and somehow a negative reference letter got fired off by this employer. And I call up the attorney. I say, "Glenn, what the hell?" Of course, he had no idea because it was just sent to some HR department.
Just sort of, this is hypothetical, by the way.
Wasn't Glenn, but it was a pitfall, and I like that. You put the letter out there ahead of time, you put it on the job, you have it, it's easy, it's clear, it doesn't hurt anybody.
Yeah, but to the point of the other time too, with the references that look, companies are sort of trained, but they're big and they're stupid times, right?
They do.
And here's the deal too, and if I know someone has been, has worked for, Tully law firm, and they moved around, and I'm thinking maybe I get an associate. Okay, I'm going to be honest with you. I'm not calling your HR person for the life of me. I'm calling you.
Yeah.
And then you're going to say, we don't do this. I say, "Mike, we've been through hell together. What are you doing?" And so the point is that not just me, but that's how the reference world works. So what I do in the agreements, if it gets down to that thing, I'll say, if you want a reference,
Send it to Mike Macomber.
you're right. You're gonna contact, Joe Schmo, my current HR manager, or whoever is in his or her place. And you will do this, and you will do this, and they will do this. And that way, if you don't do this, and you get a crap reference, tough. That's my position on that.
I think it's the only way to do it, because you're right. Otherwise, you're just throwing it up in the air and hoping something sticks.
And then the other big thing, it's obviously the money. It's an allocation issue, and that's for the tax geeks in the room. That's important. I mean, you got to get it as right as you can. I don't think I've entered in a settled agreement that totally complies with the IRS requirements, but I'm pretty freaking close. I'm closer than others because, the IRS says, most of what we do better be wages. And, It is, but I think you get a little flexibility in there, but it's allocation and attorney's fees and who gets the
I hate 70 cases in December because it leaves you zero flexibility to be like, listen, call your CPA. I'm not giving you any advice here. But when you settle it in January, they got a whole 11 months to figure that crap out.
Forget your name.
Forget my name. You're not sending me the 1099. Like, I don't have to see it anymore.
Yeah.
But if I get a settlement on December 30th, I'm going, oh crap, this is going to be taxes. It's
Yeah.
always taxes.
So
I think it's important at the end of a mediation to have a term sheet, because I would find that to be an enforceable agreement if we can't agree subsequent to that with a more formalized agreement. But when there is a more formalized agreement, I think recitals are important at the very outset. Obviously, the consideration of being, money, whatever it is that your clients want to pay mine. And the rest of it is really for your client's benefit. So I try to push back as much as possible. So we see
the releases are going to be different if I have to be a deal or for benefit.
But, I try to make it as mutual as possible, right? Dealing with me, a non-disparagement clause. I try to push back. I want it mutual. Confidentiality, I want it mutual. But for the most part, I tell Glenn this all the time. Send me a 5-page agreement, not a 25-page agreement.
And I send you a 15-page.
Right.
So we go down the middle. Bill, quick question for you. I'm sorry to kind of hog this question, but I'm just curious for my own education. What Alan just said, I said, yeah, hot spit. I like that. Mediation, right? Fortunately, I've been very fortunate in mediating with very normal, effective, sane plaintiff's lawyers. Okay, and handshakes are good. Especially locally. New York City, sometimes I got to push a little bit, but if I cut a deal in mediation or outside, with Tully firm, we know what's going to happen. Okay, but in mediation, especially with strange parties, I do like the term sheet because I do think it's enforceable. In mediation, and we're not going to get all the things that I've had them where a good mediator wrote down, okay, $10,000 wages, $10,000 compensatory damage, $10,000 attorney's fees, usual, no admissions, kind of good that, you'll have your stupid, older worker benefit language and all that kind of stuff, and non-disparagement, technical non-disparagement, one way, both ways, whatever. And then you guys are going to be admitting, you're going to supplement this up with Doherty's 15 pages because he's got charges lying for it, of course. But we all sign it and we leave. And I do think it's a done deal. Yeah, I agree. I think you can go to court with it. Assuming you're in.
Yeah, I do the same thing.
Good. I like that.
And I think
it's key.
I think it has to be in writing because I've had it bite me in the butt when it's not, where they do the verbal and the other side's completely, or they can't, or I've actually had them agree to stuff that they couldn't agree to. And then find out later on that legally they couldn't even do it. And it was all a verbal agreement. I wasn't involved in it. I inherited it and I spent the next 3 years trying to enforce it to no avail because none of it was ever memorialized in writing, even just a basic term sheet.
So one more thing, and why the term sheet's important, I think, is because it might take you 2 weeks to get me an agreement.
Yes.
My client may feel very differently in 2 weeks.
Same with mine.
Right, exactly.
Yeah, so I agree.
The longer it goes, the more difficult.
And it's really easy to say, okay, one, they could go to court. You're going to piss off that nice mediator. You don't want to do that. That's a good way to kind of close out and keep the deal tight.
Yep. Obviously, we can keep going on this for the rest of the evening and we'll probably continue to exchange war stories. Judge, any final thoughts on mediation, specific to settlement? Any other tips for the parties when they get to that point as to finalizing things?
No, I think they've sort of wrapped it up. I try to virtually never end without some memorialization. And I encourage, to be a term sheet, get everyone to sign it, make sure the clients believe they're bound and are bound to the extent that it can be in a fairly brief document that's going to be supplemented later by, much more thorough document. So I think that sort of does it.
Bill, the lightning round question, since we're out of time, here it is. You a fan of virtual mediation?
Yeah, I prefer where possible, everybody being in one place, but you really have to do it now.
In this day and age, especially if you want to expand your jurisdiction.
Yeah. And you get, even if you have cases, I'm on the Northern District panel, and you know, you have lawyers that are from all over the country.
right?
You know, I like few people, but no,
Continue.
when they give you the employment panels, people
It's horrible.
can't even spell employment law for grass.
Mediation's hard.
Oh, yeah. So you kind of, you sort of have to be.
Virtual.
Yeah. And I like it. I mean, it's good. There is a little bit of benefit when you're able to all be in, you know, conference rooms next to each other, but
You know, I would prefer in person, but it's just not practical.
yeah, it is.
It's just,
It's not, and it's harder. It's harder and harder.
Yeah.
All right. I wanted to thank you very much, Judge.
Thank
I want
you.
to thank you, Glenn and Alan. Thank you
Thank
very
you.
much.
Thank you.
Thank you, everyone.
Thank you all.